Michael Bryant, good to have you along. And I realize I look like a walking gender reveal party here. So if you got something coming up, let me know. I'll just pop right in with the proper tie color. Going to be with you the next couple of hours. Lots of stuff happening here on the Trial Network. And I think we need to begin with Atlanta, Georgia. Yeah. That is, of course, the racketeering trial against Jeffery Williams, better known as rapper Young Thug. The rapper and 5 co-defendants charged under the Racketeer Influenced and Corruption Organizations Act, RICO, for all kinds of interesting activities. This Grammy Award-winning rapper and his co-defendants, part of a criminal street gang, says the prosecution, YSL, short for Young Slime Life, crimes ranging from theft to murder. However, the defense says, no, you're ill in here. YSL just stands for the record label Young Stoner Life. This morning started with defense attorney, this was outside the presence of the jury, of course, Brian Steele requesting to cross-examine the state's key witness, you know, Mr. Copeland, about that June 10th ex parte hearing. So this is critical stuff, what he can and can't get into. Let's go into court to listen to what his arguments were and what the judge ultimately ruled would come in or not be talked about on cross-examination. Here we go.
I respectfully disagree. Okay. Mr. Copeland, on the 7th of June 2024, stated, and in my way I understand the law, he doesn't have a Fifth Amendment, but he refused to testify. And he used the Fifth Amendment as whatever, his statement. He made it clear to me as a reader of the June 10th, 2024 ex parte meeting that he was not going to testify. He said in court, outside the presence of the jury, that he was pressured. Please check the record with Ms. Winfrey. If he didn't use that word, he used a similar word. He would never have testified except for that ex parte meeting where Judge Glanville pressured him, as well as Ms. Hilton. So I believe that it does go to his state of mind while he started to testify. Your Honorable Court, correctly, in my understanding of the law, told him what is his options and how long he's looking in custody, and told him, I believe, the decision's his. The legal decision, though, will trigger you to have to exercise your discretion and hold him in contempt. So I believe that the jury gets to determine that information. In addition to that, Judge Glanville was with us since January 4th of 2023. This jury is all selected from the very first panel. To me, he was biased in front of the jury. I understand that what you said, that, no statement, I appreciate what you said. No statement made by the former court disparaging of lawyers should be considered, or whatever the words were. But there's also going to be a jury instruction that nothing that the court says is intimated an opinion. And I disagree in this case with that instruction. I'm going to object to that instruction. And I need the jurors to understand that Judge Glanville, I will make it clear. I will make it clear. I am excluding this honorable court. But Judge Glanville pressured him. And I will argue to the jury that Judge Glanville was biased. And that is admissible because it all happened in front of the jury. And from just Judge Glanville's demeanor, and I'm not here to hurt Judge Glanville. In fact, I like Judge Glanville, but I don't know what happened in this case, but I like him before this case. But the way he conducted himself to people in this courtroom, I've never really seen a judge do. So I want to ask Mr. Copeland, it is very important to me to explain that he was taken against his desire into Judge Glanville's chambers, that he was with Judge Glanville, Miss Hilton, his lawyer. I'll make it all perfect if I don't, you could admonish me and the state can correct me, but I'm not here to snowball anybody. But to say that I can exclude statements of Judge Glanville and, most importantly, the conscious or subconsciousness of this witness, because I believe, and I've not spoken with him, Your Honor. I've not spoken with his lawyer about it, but I believe that Mr. Copeland will truthfully say that he believed that Judge Glanville and the state of Georgia are one. And that comes out when Judge Glanville specifically says, and I don't remember the transcript page right now, but it's something to the effect of, we need your testimony. There's no we. Nobody needs anybody's testimony. If he didn't want to testify, I've had witnesses tell me, I'm not testifying. We subpoena them and come to court. They're held in contempt. There's nothing that the judge can do because the judge can't give immunity, so they can't compel the person to do it. So the person invokes their Fifth Amendment and they just leave. That is unfortunate, but that's a reality. There is no we. So with all that being said, I'm making an attorney proffer that if you prevent me from doing that, and Judge Glanville prevented me already, I'm just telling you, he prevented me from cross-examining Agent Racy, he's an FBI agent, on misstatements made by the prosecution, knowing misstatements, knowing the prosecution, it was Ms. Hilton, knew that a gentleman who's the same last name as a court reporter entered an invalid, coerced guilty plea. Judge Glanville stopped me again from getting into the truth of that matter. It's never been corrected. The point I'm trying to make to you is that all came out in front of the jury. So yes, I am going to intend to do, I will follow your rule, obviously, but I intend to cross-examine Mr. Copeland, not only what was said by Ms. Hilton, but what was said by Judge Glanville. I will be respectful. I'm not here to, throw some odd names about Judge Glanville. I will just be very specific. And then if he doesn't answer my questions, I'm stuck with his answer of, I don't recall, or whatever has been going on in this courtroom. But I don't believe that you should limit the cross-examination.
Yeah, this is all going just as planned. So here we have this discussion taking place between Attorney Steele, the representative for Mr. Thug, and the judge, and the ghost of Glanville rises once again to make a mess out of this attempt to move forward with this case. Luckily, I have Brian Buckmeyer here. He is a law and crime legal analyst, of course, and Katherine Lizardo. She is a trial attorney. You guys get to help me tear this apart before we hear the judge's ultimate decision on this. Brian, the issue again is that ex parte meeting from June 10 and what the court told this jury about what they could or couldn't consider relating to Mr. Copeland's testimony. Well, now it seems perfectly reasonable to me that Steele would want to cross-examine on what impacted his decision to testify. What am I missing here?
Yeah, I think I agree with what you're saying, and I agree with where Brian Steele wants to end up, but I don't like the path in which he's trying to get there. And the reason why I don't like it is because I think it gives a judge easy pushback. He's basically saying to this judge, Judge Whitaker, I want to go after one of your colleagues. I want to go after Judge Glanville for what he did wrong and how he kind of put his thumbs on the scale of justice in this case. And I don't think, just from a human aspect, you're going to get a lot of a well-warmed welcome from that from someone on the bench. I think what you're articulating is a better route. I want to attack the credibility of the witness, the reason why he chose to testify, the reason why he chose to testify in the way that he did. And part of the way I do that is by getting the statements of the judge to see what impact it had on this witness. I think that's a better route to go. And this way you're not throwing any judges under the proverbial bus.
Yeah, and Katherine, there was a discussion where the judge, Judge Paige Whitaker, said, look, anything I say is not to protect Judge Glanville. And then she goes forward with what sounds like she's protecting Judge Glanville. How do you think she's handling this?
Well, it is a very tricky situation, as what Brian mentioned, where she has to respect her colleague and show deference to the judgeship. So she has to balance that out. What I find interesting is with what Brian Steele is arguing, the judge eventually, or Judge Glanville eventually became a witness because of that ex parte meeting. And he wants to mention what Judge Glanville said, the testimony in the transcript during that ex parte meeting, and which I completely understand because it influences the witness. But then I think if that happens, Judge Glanville should also be allowed to be a witness and be at the trial so that he can explain what was going on. So that puts more wrinkle and possibly confusion to the jury as to what's going on if a judge goes there and tries to support what he was saying.
Okay, guys, real quick. Brian, you got A, B, or C. It's going to be allowed, the cross-examination, disallowed, or some splitting of the baby. Your thought first. Couple of words.
Yes.
Okay.
I think some splitting of the baby, but I also want to make this one correction as well. It's Chief Judge Glanville. Understand his position in that courtroom. So it's like saying, oh, I don't want to say anything bad about the chief. I'm an associate judge. There's a reason why you don't come after the chief like that with associate judges.
But I think there's a little shine off the judge at this point. Okay, Katherine, your 2-word, 3-word. Is it going to be allowed, disallowed, or some splitting of the baby?
Splitting of the baby.
Okay, here we go. Let's find out what the judge had to say after the Steele arguments. Here we go.
I understand your argument, and I am not making my ruling in any sort of an effort to protect Judge Glanville. I do not believe it is relevant to the issues for this jury to determine. With regard to whether Mr. Copeland's testimony between the 7th and the 10th was, I'm sorry, between the 10th and the 12th, was impacted by the ex parte on the 10th. I asked everybody, do we want to do the entirety of Mr. Copeland's testimony over? And everybody said, no, we want what got testified to between the 7th and the 12th at 3 p.m. So y'all had the opportunity to have it all done over, and you chose not to do that. You can ask him about the immunity and whether he'd be testifying without being ordered to. That's fine. But beyond that, the ins and outs of what happened in the ex parte with regard to whether there was a biased judge or not are, in this court's legal opinion, not relevant to these issues. And honestly, even the "we need your testimony," Judge Glanville had made a determination that Mr. Copeland's testimony and compelling that testimony by an immunity grant was in the public's interest. And so the "we" there is Judge Glanville, or can very easily be understood to be Judge Glanville saying "we, the public," and not "we, me, and the state." So I appreciate your proffer, but my ruling stands.
I don't like it. I don't like it at all. I think that she's really, really going out of her way to protect Chief Judge Glanville, although he may lose that title, who knows. So, Brian, she makes this distinction that, hey, you guys had a chance to, object to testimony from Copeland coming in between the 10th and the 12th. The 12th, the day that the recusal motion was made. That's the date upon which there's kind of a break in the action. And they said, no, we want to hear those 2 days are fine. What does that matter? I mean, that's totally irrelevant to the motivation, bias, intimidation this witness may have felt to testify at all.
Yeah, those were a lot of words. I understand they come from the English language from that judge, but none of them made sense. To your point, that distinction doesn't make sense. Also, later on in her ruling, where she's trying to infer what the judge meant by "we." First of all, you can't do that. You don't know what that person meant. Second of all, it has no bearing as to what he meant when he said it. It has a bearing as to what the listener believed that to be, that being Kenneth Copeland. So Kenneth Copeland hears "we," and I've represented about 4,500 people in about a decade as being a public defender. No person goes before a judge and thinks "we" means the people or the county or the city. They think "we" means the prosecutor and the judge.
Of course,
I think the judge got
Brian. They think "we" like "we the people," like in the Constitution. And I think that was really digging a hole for herself, Katherine. And again, we don't have to look far to find appellate issues in this case if there is a conviction. But what do you think about this maneuver by the judge?
That "peel" word popped in my mind immediately. Wow, I can just imagine what the appellate brief will be for this case regarding that, because like Brian mentioned, she was assuming or speculating what Judge Glanville meant with the word "we." I have to say, when she was explaining her argument, I thought, wow, that's very creative of her to say that whatever testimony was said before, because the parties said that they want to keep that and they don't want a do-over, it became the party's fault per se as to why now she's ruling that whatever was said during the ex-party meeting was irrelevant, because then the jury still has that testimony, and if we don't do that over, then what's the point of the ex-party meeting? It did not affect anything that was said before the ex-party meeting.
Yeah,
it sounds creative, but not effective.
No, it's a mess. And, you know, to impute her understanding of we, which just happened to conveniently work for her, to somebody else, as Brian suggests, I mean, that's really going a long ways. Okay, we'll get back into this case. When they reconvene, we hope in front of a jury at some point. We believe the witness Zachary at some point is coming up too, but cross-exam of Lil Woody. Do you want to miss that? I don't think so. Let's take a break. When we come back, you got a nasty neighbor. Well, Susan Lawrence thought she had a life-threatening neighbor, and she shot her through the door, killed her. That case coming up right after the break here.